Well, the New Mexican compound where suspects reportedly conducted a Jihadi training camp for children is taking center stage amid national controversy. A judge issued signature bond for the defendants earlier this week, essentially letting them go free with a signature and a promise to appear for trial. One America secured an exclusive interview with Executive Director of the American Bail Coalition, Jeffrey Clayton, to talk about this case. Here's Bailey Byers.
Outrage has spiked nationwide as Democrat Judge Sarah Backus releases 5 suspects accused of operating a Muslim extremist camp, allegedly training children to become school shooters in New Mexico. However, many officials are saying New Mexico's bail laws are to blame for the controversial decision. Also known as Constitutional Amendment 1, the new bail measure was passed overwhelmingly back in 2016, and it does not require defendants to post monetary bail if they are not deemed a flight risk. The caveat lies within the somewhat subjective notion of what exactly constitutes a flight risk and danger to society. The prosecution has the responsibility of proving the defendants are dangerous through clear and convincing evidence.
If it was a low-level crime or something small where you could prove you weren't a flight risk or a danger and you're being held solely because you can't afford your bail, then you could file a motion to have a hearing on that.
One of the prime motives behind the amendment is the idea that posting money bonds does not enhance public safety, so defendants should be released contingent upon their risk to society and not ability to pay. But critics claim Judge Backus seems to be doing the opposite with her controversial decision. One America secured an exclusive interview with legal expert and executive director of the American Bail Coalition, Jeffrey Clayton, to gain additional information regarding signature bonds.
Well, in the business, we call it an unsecured bond, meaning that it's a pledge to pay a forfeited amount of money if you fail to appear. The thing is, if you fail to appear, you're not going to pay it because you're not coming back. And what we've learned over the years is that, one, the state never collects them when they do forfeit them.
Clayton continued by saying the only way defendants are able to be held behind bars prior to the trial is if and only if the prosecutor can provide, quote, clear and convincing evidence. According to the amendment fact sheet, fixed money bond schedules can result in violent criminals returning to society, assuming they are able to pay a high price. Clayton suggests a critical problem with being able to prove the suspects are a danger to society lies with a lack of funding within the district attorney's office.
The legislature, nobody ever funded the district attorneys and the prosecutors and the judges to have these hearings. So this is why the judge can go in and say, well, you can't prove by clear and convincing evidence in New Mexico because they never got any resources to do the hearings. They're strapped.
He continued by saying anyone the court detains pre-trial has to use its own resources to provide clear and convincing evidence, and this is a hefty responsibility for the district attorney's office. Clayton weighed in on the likelihood of the suspects appearing for trial, suggesting there is a fair chance they will flee.
I absolutely think they can flee the country, and it would not surprise me if they tried. Nobody's going to go get these guys if they take off. They'll issue an international warrant, but there's no bail company that's going to go after these guys. And so, depends on if they get charged with homicide.
Monetary bonds are still permitted in the state. In the event, it's necessary to encourage court appearances. Bailey Byers, One America News.
Want to see more videos like this? Click on the link below and subscribe to One America News on YouTube. And call your cable provider and kindly demand that One America News is added to your lineup. Call and subscribe today.